So I'd like to open by saying thank you. It's both an honor and a privilege to appear before this committee to talk about this very important issue. Ms. Enenajor and I are here on behalf of the Criminal Lawyers Association. We're an association, a not-for-profit organization of 1,000 criminal defense lawyers, and the objectives of our association are to educate, promote, and represent both ourselves and the people we represent on issues relating to criminal and constitutional law. Our association has routinely appeared before committees such as this one and has intervened in appeals in both the Court of Appeal and the Supreme Court of Canada. The CLA supports legislation that's fair, modest, and above all else, constitutional. I'll be honest with you, C-45 is a difficult bill for me personally and for us as an organization. It's difficult because we know as criminal lawyers that the war on drugs has been a complete and abject failure. The social and financial cost of drug criminalization outweighs any illusory benefit, and this applies, I think there's no better example than the prohibition against cannabis. Every year, scores of young men and women are incarcerated, are stigmatized, and are killed over relatively small amounts of marijuana. Marijuana criminalization imposes unreasonable penalties on a relatively low-risk vice. In the real world, a record for simply possessing marijuana means limited employment opportunities, limited travel opportunities, and other devastating collateral consequences. These costs are more often borne by the marginalized, the impoverished, and the racialized. In simple terms, it's the criminalization of marijuana, not marijuana itself, that creates these harms. So in that sense, we welcome the legalization of cannabis, but that's not what this bill really does. It doesn't legalize cannabis in enough situations. It doesn't go far enough. And most importantly, it's littered with unconstitutional sections and provisions that will be struck down by the court soon after they're enacted. Under this bill, youth are punished and criminalized more than adults are. A 17-year-old who possesses 6 grams of marijuana is a criminal, will be arrested, and will be prosecuted. His 18-year-old friend standing beside him who possesses more marijuana, as much as 30 grams, isn't committing an offense. This asymmetrical criminalization appears nowhere else in the criminal code and should be a red flag to this committee. It's discrimination on the basis of age. It will be found to be unconstitutional. There's many other problems in this bill. I'm going to talk about ticketing next before I turn over the last few minutes to Annamaria. The ticketing provision also discriminates against the young. They're not allowed to partake in that. They're going to be forced down the criminal path. There will be no discretion for police officers or for prosecutors to afford youth the benefit of receiving a ticket. But that's not even the worst problem with that ticketing provision. The ticketing provision is good in that it can divert adults away from the criminal law process, and it's good that it seals the court records so that some of those criminal collateral consequences don't follow adults down this ticketing path. But we know youth are excluded, and we know that the poor will continue to be marginalized and to continue to be discriminated against through this ticketing regime, because you can only take advantage of having your record sealed if you're rich enough to pay the fine within 30 days. There is not a clear case of discrimination. There is not a clearer case of an unconstitutional provision. It's the lowest hanging fruit. I'm going to turn it over to Annamaria, who's going to talk about some other problems with the bill.
Thank you, Michael. Good afternoon, Senators. I will be addressing 2 issues that the Criminal Lawyers Association have flagged as problematic in Bill C-45. One of them deals with the collateral immigration consequences of some of the offenses as they're written in the bill. And the second is a glaring blind spot in the drafting of the bill, which is that the bill does not take into consideration and does not mitigate in any way the horrendous negative stigma that is attached to the criminalization of cannabis in Canada and the consequences that that has for so many Canadians. The penalties for the offenses in Bill C-45 are quite stark. In contrast to current legislation for marijuana, for example, Bill C-45 increases the maximum penalties for distribution of 3 kilograms or less of marijuana from 5 years to 14 years. As a consequence of this increase of the maximum penalty associated with this offense, more Canadian permanent residents and residents of Canada will be facing unwarranted threats to their lawful status as a result of conviction of these offenses. Section 36 of the Immigration and Refugee Protection Act considers individuals criminally inadmissible in Canada on two bases. First, if they are sentenced to a custodial sentence of 6 months or more, and second, if they are convicted of an offense that carries a maximum of over 10 years. What Bill C-45 does is it raises the maximum for a number of offenses relating to marijuana possession and distribution over that 10-year mark, making more Canadians who are participating or who have committed offenses that are relatively a low-risk vice. It subjects them to deportation from the country and potentially detention in the interim. What this looks like in practice is that if an 18-year-old Canadian permanent resident is convicted of passing a joint to his 17-year-old friend, he will receive a deportation order, even if he only receives a suspended sentence and no jail time, which reflects the actual moral gravity of the offense under the criminal system. The impact of these collateral consequences can be quite stark and obviously will be disproportionately felt by many people who are in vulnerable positions in Canadian society. People who are newcomers to Canada and immigrants and permanent residents often face issues with mental health problems and mental health issues, as was discussed by the Schizophrenia Society of Ontario in a paper that was presented in 2010. In terms of the proposed legislation, it does nothing to address the stigma of the history of criminal convictions that are visited on Canadian people. And we know that disproportionately these convictions and the policing of cannabis has been felt by Indigenous Canadians and other vulnerable groups such as Black Canadians. And the result of not addressing the impact that this has on these individuals' lives is that they will continue to be stigmatized and criminalized, and they will continue to be subject to the invasive nature of state surveillance until this issue is addressed. And in our submission, this is a disproportionate consequence that the bill does not foresee.
Very much. And now from the Canadian Bar Association, I think we're starting with Galen Schellenberg. Okay.
Good afternoon, and thank you for the invitation to present the Canadian Bar Association National Criminal Justice Section's views on Bill C-45 to you today. The CBA is a national association of over 36,000 lawyers, law students, notaries, and academics, and our mandate includes seeking improvement in the law and the administration of justice. Our National Criminal Justice Section represents a balance of Crown and defense lawyers from all parts of the country. And with me today is Paul Calarco, a defense lawyer from Toronto and an executive member of our section. Mr. Calarco will summarize highlights of our submission, and respond to your questions. Thank you.
Thank you. Honorable Senators, since 1978, the Canadian Bar Association has advocated a different approach than has historically been taken in this country to the possession and use of marijuana. Experience has demonstrated that absolute prohibition has not worked, but resulted in the distribution of this drug on the black market. It has spurred the growth of criminal elements and led to many people having damaging criminal records. At the same time, those who needed this drug for legitimate medical purposes were, until recently, denied access, forcing them to purchase it illegally. A better system was and is required. The Bar Association in 2013 urged the government to adopt a harm reduction model for drug use, seeing it as a social and medical issue, not primarily a criminal law matter. This is not to say that the Bar Association is blind to the harms associated with drug use, but, put simply, widespread criminalization has not worked. Bill C-45 would take a regulated industry approach to one part of drug use and distribution. It's a major and multifaceted initiative, but with any major and complex change, it is more important that it be done right rather than just done quickly. The bill is a positive step towards treating cannabis use and possession in a non-criminal way, but the CBA section continues to have serious concerns with the legislation, and I will address a few of these. First, Bill C-45 would too often result in people moving from lawful activity to serious criminality with severe penalties when there is little factual difference between their situations. We urge careful consideration to the everyday examples that our section and others have provided as to how proposals would affect ordinary Canadians. The message that Canadians, or many Canadians, have now is that cannabis will be completely legal soon. This is not so. The bill maintains a strong criminal regime for many aspects of possession, distribution, and cultivation, and clarity is essential. Second, the sentences in Bill C-45 should be reconsidered. The proposed penalties are far beyond what is being imposed in our courts today. Even when there are large marijuana grow operations found, sentences of 14 years have not been considered by our courts. But this bill will preserve a maximum of 14 years and massive fines, or 5 years less a day for simple possession. And even if offenses are prosecuted summarily, jail terms and fines are still very high. Conditional sentence orders are not available where the Crown proceeds by indictment, and discharges will not be available at all since the maximum penalty is 14 years. We suggest that legislatively determined sentence ranges reflect the actual sentences currently imposed and allow for alternative dispositions such as conditional sentences and discharges. And that means that the maximum penalties must be reduced. In addition, we urge that until the current legislation is replaced, prosecutions be conducted consistent with the spirit of the new legislation and non-custodial terms be sought whenever reasonably possible. The CBA has long opposed mandatory minimum sentences, and we suggest that these not be used in the interim period. Thirdly, the ticketable offenses regime set out in sections 51 to 60 is quite limited, referring to a maximum of 50 grams or 5 to 6 plants, and in regard to cultivation, 1 to 2 plants over the legal limits. Consideration should be given to a wider range of ticketable offenses. And we also caution that the discretion granted to certain authorities be carefully monitored, because discretion may be a means to furtherly marginalize vulnerable or racialized groups. The legislation should be amended to require, rather than permit, ticketable offenses to be used unless they are inappropriate in the circumstances. Fourth, these proposals are not reflective of social conditions in many parts of the country where people may not have access to legal supplies of cannabis, but are not allowed to have longer-term supplies. For example, criminal provisions set limits of 30 grams for adults, 5 grams for youths, 4 grams per residence, no matter how many people may be living there. Transport provisions are restrictive, as are the prohibitions on non-budding or flowering plants. This means that people who may be living in a more communal way, or reside in remote areas, or simply wish to transport a larger supply for a number of willing adults would be subject to severe penalties. And for youths, there is no legal way for youths to obtain cannabis. It's unquestionably desirable to educate and discourage young people from using drugs, but it's clear from past experience that there will be use. The bill as it is will create, not eliminate, a black market. And while it's recognized that youths may distribute amongst themselves up to 5 grams of cannabis without criminal penalty, it does not allow for a legitimate source of marijuana to be obtained. And at present, the regulations, which are an essential part of the new substance control regime, have not been published. In moving towards a regulated industry model, it is essential that industry know what is permitted and what is not. A breach of the regulations can result in imprisonment and very heavy fines, but businesses cannot prepare for whatever the regulations may be in order to model their affairs and remain on the right side of the law. This must be addressed. And at the appropriate time, I'll be pleased to answer questions of the senators.
Thank you very much. Et maintenant, Bureau de Québec, Pascal.
And now the Barreau du Québec, Pascal Levesque. Mr. Chairman, Vice Chairpersons, members of the committee. My name is Pascal Levesque. I'm the chair of the Criminal Law Advisory Committee of the Barreau du Québec. And it's with tremendous interest that the Barreau du Québec is testifying before you today concerning Bill C-45 entitled the Cannabis Act. As a professional association, the Barreau is mandated to protect the public. Legalizing and regulating cannabis has a number of potential ramifications for society from a legal, health and public safety standpoint, which is precisely why the Barreau Association has such a stake in this matter. And that is why I thank you for inviting the Barreau to share with you our position on the matter of legalizing and regulating cannabis in Canada. Broadly speaking, without taking a stance on the timeliness of legalizing cannabis, the Barreau is in favour of Bill C-45, which sets out a comprehensive regime and clear measures concerning production, distribution and the sale of this substance. We would like to reiterate, however, a number of major issues that are worth highlighting with a view to protecting the public. First, we want to reiterate the importance of awareness building, prevention, education, and particularly legal initiatives for the public and particularly our youth. In order to enable the public to make an informed choice regarding the use of recreational cannabis, funding for research on a variety of areas must be given in terms of health, sociology and the law. In fact, even if cannabis does soon become legal to consume, the fact of the matter is that it does have a number of harmful effects. The decision to legalise cannabis was based on a cost-benefits analysis, but it is only with the benefit of time and experience that we will know whether the choice was the right one, needs reconsidering or even overturning. As far as the need to continue this research, let's not forget that Canadian youth are the ones that consume cannabis the most. Indeed, Statistics Canada has informed us that the age group that uses the cannabis the most often is 18 to 24-year-olds, closely followed by 14 to 17-year-olds. Youth must therefore be more closely targeted in education and prevention campaigns. The Cannabis Act criminalises the possession of cannabis more strictly and stringently for minors than it does for adults, by setting a limit of 5 grams or less for any possession of cannabis for a minor, in contrast with 30 grams or less for persons of 18 or older. The Barreau stresses how important it is to not criminalise minors for behaviour that is permitted among adults. And let's not forget that this is a particularly vulnerable population that must be adequately protected. Let's remember that the teenage criminal justice system is different from its adult counterpart. It is based on a principle of a lower threshold of moral blameworthiness or culpability, and must focus on rehabilitating and reintegrating into society our youth. We must avoid subjecting our youth to the serious ramifications of a criminal conviction or record. Given how important it is to not criminalise youth for the simple possession of cannabis under the legal limit, we recommend that possession of under 30 grams of cannabis be decriminalised for youth. The onus will be on the provinces through ticketing to sanction the use of cannabis among youth. Some provinces are proposing to do so for any quantities up to 5 grams. In Quebec, it's under Bill C-57. The ticketing regime set out in the Cannabis Act does not apply to minors. The regime stipulates that individuals of 18 and over who commit a number of offences may be prosecuted by way of the issuance of a summons or a subpoena. And the adult criminal justice system is being foisted on a particularly vulnerable age group. We believe that awareness building, education and prevention are the best tools to eradicate the use of cannabis among our youth. You can't expect the criminal justice system to compensate for an education and prevention system that is sorely lacking. As far as labelling standards that are set out in the Cannabis Act are concerned, it is a sine qua non condition for the barreau that stringent labelling standards are necessary to meet the objectives of, in terms of information prevention and in certain cases among our youth, deterrence, which must be the backdrop to regulating cannabis broadly speaking. Let's remember that Bill C-45 stipulates plain packaging, particularly in terms of colours and font. In its brief on Bill C-45, the Barreau de Quebec is calling on the federal government to institute more stringent national standards that would include factual information and photos akin to what we currently see on cigarette packs. In closing, the Cannabis Act recognises the authority of the provinces and territories to authorise and to monitor the distribution and sale of cannabis subject to the adherence to certain minimal federal standards. However, this list is not exhaustive, particularly with respect to what would fall exclusively under federal jurisdiction. And this can be confusing as to what the provinces need to bear in mind when they legislate the retail sale and distribution of cannabis. Consequently, for greater clarity, lawmakers should amend the Cannabis Act. So there you have it, Mr. Chairman. That was a brief overview of the main issues the Barreau wished to raise with you as a part of the consultative process on Bill C-45. There's more in-depth explanations on the various issues that we just presented in our brief, which we submitted and which is also available on the Barreau du Québec's website. We hope that our submission provided food for thought, and I'm now available to respond to your questions. Thank you.